our group will represent the three elements of the industrial property of the IP law. So we continue to present for you the patent utility solution design and the trademark. So the first section we say we will answer the question about describe the inadequacies in the patent protection condition in Vietnam and condition for the protection of the industrial design plan. So he will present for you.
I will presentation the first question. The first question is describe the inadequacy in the patent protection condition in Vietnam. According to Article 58 of the Intellectual Property Law 2005, the general condition for protection for invention are: an invention shall be protected by mode of grant of invention patent when by the following condition: being new, involving an inventive step, being susceptible of industrial application. Unless it is a common knowledge, an invention shall be protected by mode of grant of utility solution patent when it satisfies the following condition: being new, being susceptible of industrial application. Some inadequacy in patent protection. Broadly, there is no clear distinction between the concept of patent and utility solution. The Intellectual Property Law 2005 only states the concept of without mentioning utility solution. Furthermore, only inventions are regulated as subject of industrial property right, while Article 58 provides for general conditions for invention. Secondly, Circular No. 1/2007 was issued on 14 February 2007 is considered an important document in determining the process of establishing intellectual property right for invention. However, in the application process, some shortcomings and limitations have been that are inconsistent with the intellectual property law. For example, in Classic Article 23 of the Revision on Invention Description, the patent application must show the object to register in the requirement. There is no similar revision, only that the invention name must be clearly and succinctly state the technical specification on the patent rather than a crypt representation of the subject matter. Such a clarification will cause difficult for applicants when there are many inventions in the application. Multi-subject or independent claims for different subjects. Therefore, the requirements for are difficult to meet. Third, at point P, clause 3, Article 25 refer to a denoted method as a protective procedure. However, in clause 7, Article 59 of the Intellectual Property Law, these subjects are not recorded as invention. Third, there exists a contradiction in the interpretation of the denoted method between the Intellectual Property Law and Circular No. 1/2007. For point P, clause 5, Article 25 provide for the assessment of novelty. First, two technical solutions are considered identical when all the basic size, feature, consign are equivalent. Second, two technical solutions are considered similar when most of the basic size are identical or equivalent. Can this term equivalent be understood as equivalent patent as defense for the assessment of patent infringement? Fifth, on the clause Article 25 stipulate the assessment of novelty of the basic size of the upright solution to be compared with the size of the control solution, in which basic size of technical solutions stay in the application and in the protection total are expressed in the scope claim for protection of the invention. This is an omission of the circular when does not specify what type of protection total is stated, because if it is a total presented as a reference, the comparison cannot be carried out only with the sign mentioned disclosed in the repository of the document, but with all that is disclosed in the full text of the title. Finally, many revisions on patent protection are not compatible with international conventions. Considering the intellectual property law revision of our country, we see that there are still many regulations that are not compatible with international conventions, to which Vietnam has been and will be a member, including revision on protection of intellectual property rights patent in biotechnology. Globally, biotechnology is recognized for its importance and protected by law. The practice of the European Union and the United States show that protection innovation in the field of biotechnology bring great benefit to many areas of life, as well as economic and social development. International treaty protecting invention in biology, biotechnology were formed very early. The most basic international convention related to the field of biotechnology include the Paris Convention for Protection of Industrial Property Rights of 1883, Convention on Biological Diversity 1992. However, Vietnam had not joined any international convention in the field of biotechnology and had not issued legal document, independent legislation to protect biotechnology invention. The second question is condition for protection of industrial design. Explain. According to Article 63 of the Intellectual Property Law 2005, the general condition for protection for industrial design are being new, being creative, being susceptible of industrial application. Novelty of industrial design. An industrial design shall be considered new if it significantly differs from other industrial design that have been policy disclosed through use or by means of written description or in any other form inside or outside the country, real to the filling day or the reality day at application of the industrial design, registration application. To industrial design so not be considered significantly different from each other if they are not only different in appearance, feature, which are not easily notable and memorable, and which cannot be used to distinguish the industrial design as whole. An industrial design shall be considered having not yet been publicly disclosed if it is known to only a limited number of persons who are obligated to keep a secret. An industrial design shall not be considered having lost its novelty if it is publicly in the following case, provided that industrial design registration applicant is filed within 6 months from the date of publication. Industrial design is published by another person without permission of the person having the right to register it defined in Article 86 of this law. Industrial design is published in the form of scientific representation by the person having the right to register it defined in Article 86 of this law. Industrial design is displayed at a national invitation of Vietnam or at an official or officially recognized international exhibition by the person having the right to register is defined in Article 86 of this law. Creativity of industrial design. An industrial design shall be considered creative if based on industrial design only publicly disclosed rule used or by means of written description or by any other firm inside or outside the country before the filing date or the reality date as applicable of the industrial design registration application. It cannot be easily created by the person with average knowledge in the art. Susceptibility of industrial application of industrial design. An industrial design shall be considered susceptible of industrial application if it can be used as a model of mass manufacture of produce with appearance, embodying such industrial design by industrial or handicraft method. However, it should be noted that the following subject matter shall not be protected: A. Industrial design appearance of a product, which is dictated by the technical feature of the product. Appearance of a civil or an industrial construction work, shape of a product, which is invisible during the use of the product. The third question: what requisites must be marked satisfied in order to serve a trademark? Two basic requirements must be met for mark to be eligible for trademark protection. It must be in use in commerce. That the mark is used in commerce arise because trademark law is constitutionally grounded in the congressional power to regulate interstate commerce. If a mark is not in use in commerce at the time the application for registration is filed, registration may still be permitted if the applicant established in writing a good faith intent to use the mark in commerce at the future day, excluding right to a trademark and acquire a first to use it in commerce. The second, it must be distinctive. That a mark be distinctive, acquired and trademark capacity for identifying and distinguishing particular good as emanating from one producer or source of not another. In determining whether a mark is distinctive, the court group mark into 4 categories based on a relationship between the mark and the underlying product. The first is arbitrary or fanciful. The second is suggestive. Third is descriptive. And four is generic. The first, an arbitrary or fanciful mark is a mark that bears no logical relationship to the underlying product. For example, the word Asian, Kodak, and Apple bear no inherent relationship to their underlying product. Repeatedly, gasoline, camera, and computer, arbitrary or fanciful marks are inherently distinctive capable of identifying an underlying product and are given a high degree of protection. The second is a suggestive mark, is a mark that suggests a characteristic of the underlying good. Some exercise of imagination in it to associate the work with an underlying product. At the same time, however, the work is not totally unrelated to the underlying product, like arbitrary or fanciful marks. Suggestive marks are inherently distinct and are given a high degree of protection. The third, the descriptive mark is a mark that directly describes rather than suggests a characteristic or quality of the underlying product. Its color function, dimension, for example, Holiday Inn, Outbrand, or Vision Center, all describe some aspect of the underlying product or supply, respectively, hotel room, breakfast cereal, optical supply. They tell us sometimes about the product. Unlike arbitrary or suggestive marks, descriptive marks are not inherently distinctive and are protected only if they have acquired secondary meaning. Descriptive marks must clear this additional hurdle because they have terms that are useful for describing the underlying product and giving the particular manufacturer the exclusive right to use the term could confer the unfair advantage. Finally, is a generic mark, is a mark that describes the general category to which the underlying product belongs. For example, the computer is the generic term for computer equipment. Generic marks are entitled for no protection under trademark law. Third, a manufacturer selling computer, brand computer, or Apple brand Apple would have no exclusive right to use that term with respect to the generic terms are not protected by trademark law because they are simply too useful for identifying a particular product, giving a single manufacturer control over use of the term could give the manufacturer to create a competitive advantage. Next two will continue to presentation.
Next to the question 4. Compare the rotation condition, contractual design, and trademark invention, utility solution, delegation on other subjects to the rotation on the industrial robotics right. The robotics established the basis of the decision on one of the robotics title by the current competent by state agencies from a law 1 article 6 the law on the intellectual property is run certificate of the rotation by the International Office intellectual property under the Ministry of President and technology. The process of granting a rotation title is the similar right of right and allegation are the relatively similar, difficult invention. Article 15A invention shall be the eligible for the protection, the form of the grant of the invention based on either specify the following condition. A is the novel. Article 16. B it is advances narrow. Article 16.1. C is accessible to industrial application. Article 16.2. Next to the trademark. Article 16.3. The trademark shall be eligible for the protect when the satisfy the following condition. A. It is the visible side, the form, the letter, work, the branding and images in including horizon or the combination therefore represented on one and more the color. B. This is the capable in the investing certain goods and service or the trademark order from the order of the suggest there and doesn't fall into the case display on the list 2 of the article 16.4 side the eligible for the rotation of the trademark. Article 17.3 the code. The next to industrial design. Article 16.3 the industrial design shall be eligible for the protect when the satisfy the following condition. A is the enable. Article 16.5 B it is pre-artist narrow. Article 16 C it is the susceptible for the industry application 16.11 and the utility solution. Larger Article 15A unless an invention common the knowledge it shall be the protected in form of run on the utility solution based by the satisfy the following condition. A it is novel, the standard of the lesser than the novelty, the invention because many the country request does not call solution that only need to be the novel wisdom, the national territory and protects on the utility solution. B this is accessible to the industrial application. The reflecting from the inventionist is larger than the for the invention. The next two exercise. 3 exercise. The firstly, analyze the judgment no 113 sheets. 2011, the Supreme People Court the Ho Chi Minh City about Phương Nga Company suing the Long Phước Company defending the right of the utility solution assessment the Genpost system. Phương Nga Company the building manufacturing company the limits lenses appeal to the court to appeal the Supreme the People Court in Ho Chi Minh City in the 2011 sued the Long Phước Company defendant issue due the patient utility solution did the company and real that it was the infringement of the right the Phương Nga Company in request Long Phước Company completely top you in and publicly apply apologize. Question A. Analysis of the rotation condition right on the utility solution according to Law 3. Article 15A. The letter property right unless on the invention of be uncommon knowledge is based the road test the form of the run, the utility solution based on one that satisfied to the following condition. A is the novel, the sender law, London is the advantage in the invasion because some country request the snorkel solution one only net to the naval visiting that the national territory and to be the protected as the utility solution. B it is accessible to the industrial application requirement for the invented net level 1 than for the invention. Utility solutions are not necessarily are separate to address other while with the invention basic from the invention. But the utility solution center the transport system, the rotated under the patient and utility solution. It has run the patient by the nation office the internet lateral property of the utility solution now 662 with the test time of the 10 year from the May 8, 2006 question 3 has Long Food Company in fact the right in a useful solution why the system decided Long Food has an inspired the right of the useful solution Phương Nga Company firstly according the assessment the conclusion on the identity is the intellectual property say the Senman transport station same system of the Long Food is designed train Apple on March the 30, 2005 and now with discussion designed by Mr. Tuấn that is different inside is identical and confusing with the right the useful solution no 662 of the Phương Nga Company. The second the person with the relay right and allegation who are the harder boss useful the solution also confine the technology narrow to the two solution completely different depending on the distance electoral robotic right the Western for is the code the access for Phương Nga changing condition production company the code didn't accept the latest Apple for the company the Phương Nga Company and uphold the first standard judgment because the system design of the Food Company is not the similar that the Phương Nga Company which is then got tested by the intelligent solution no city for and optimization the design manufacturer of the tree the system on contact with the assessment the collusion of the two authority. Question 5 do you agree with the court resolution the group agree with the court resolution the court respondent decision with intellectual property right and go tested the right the lenses order to the utility solution firstly to have the basic when the case firstly is done the court in that solution station of the accepted in the intellectual property sentence is the entitled in the National Office Intellectual Property. The exact conclusion is this in the decision of the invention to the court before defendant essentially decide decision confusedly similar the lenses utility solution. The second summer the people with the relay interest the obligation who are the harder poster whether a useful solution confine technology narrow to up to the solution confine different defendant for and he doesn't imply in the open the landscape Robert Sprite and side involve the spot. This is the lesson of the business when it lost in using interior property and robustness to be away the roadless the interior intellectual property by themselves requirement for the protection at the consistent say agency basically and nation office intellectual property based will be important against the in the court that to handmade decision.
So I will maybe send the link to choose 1109 2015 day September 29 2015 of the people.
Cái loa nó bị gì á bà ơi? Không nghe gì hết trơn á.
Hôm nay có đeo tai nghe không? Mở tai nghe ra. Coi chừng cái tai nghe nó bị ghẻ.
Giờ nghe không? Giờ nghe được không? Nghe rõ không? Hay là nhỏ?
Nó nhỏ xíu luôn á mày.
Thanh Mai nói lại, Thanh Mai.
Có được không? Hay là còn nhỏ vậy? Hello? Nghe được chưa vậy?
Nghe được rồi, mà hơi nhỏ chút. Nói đi.
Okay.
We move to the case summaries. The plaintiff is Unilever Vietnam International Co. Limited, and the defendant is Đại Việt Phương Trading Production Co. Limited. Recently, the plaintiff is a company specializing in the production and distribution of production rising to carry out wholesale and retail trade, including dishwashing liquid products, supplies. The petition is that the company is manufacturing and distributing dishwashing liquid with the campus brand name that infringe on the intellectual property rights of Unilever companies. Specifically, based on the inspection's conclusion, the bottle design of Campbell's is not significantly different from the bottle design of Sunlight. The plaintiff says that Unilever Sunlight dishwashing liquid products were framed. The certificates of trademark registration and the design bottle of Sunlight has been granted a patent for industrial designs by Unilever NV companies. This company has signed a technology transfer contract with Unilever company in order to transfer the intellectual property rights of on trademark and design to Unilever. The plaintiff also alleged that the respondent's products and sale of compact trademark products with bottle design infringe without the consent of Unilever companies. The owner of the act of infringing upon the right to the protected industrial design bottle has violated the provision of the law on the protection of intellectual property right. We move to the commentaries. First, summaries of legal matter. Plaintiff sued the defendant for infringement of intellectual property right for Campbell's bottle sticker because the bottle's design is not significantly different from Sunlight. Second, what is the subject of dispute? The object of dispute between Unilever Company and Đại Hưng Company is about industrial design. Specifically, Campbell's bottle design from Đại Hưng Company is not significantly different from Sunlight bottle design from Unilever Vietnam International Company Limited. Second, what are the conditions of protection? The term of protection in the above case is industrial design. Industrial design is a rather specific object of industrial property rights, unlike other groups of objects that protect internal elements. Industrial design protects external elements of product, light and color, the aesthetic values of industrial design. Sunlight dishwashing liquids has been granted a patent for the industrial design and trademark. Within the scope of this article, only legal issues for industrial design are mentioned. Commenting on the issues, there should be three elements. First, the novelty of the industrial design. Campbell's bottle designs had directly infringed on Unilever intellectual property rights by Sunlight dishwashing liquids. In order to prove an infringement of industrial property right to an industrial design, their infringement must occur within the validity periods of valid protection titles. An industrial design, that means novelty doesn't have to be publicly disclosed. Regarding the scope of assessing the novelty of an industrial design, the novelty of industrial design is compared with novelty around the world. However, the law will stipulate some case where an industrial design is considered to haven't been publicly disclosed if only a limited number of people know and are obligated to keep the industrial design series. The condition of number of a person does not affect the series of invention. In addition, the law also provides for all the situations where an industrial design is not considered to have lost its novelty if it is published in the following case, property that the industrial design registration application is filed within 6 months from the date of the publications. The law provides for these cases that are not considered to be loss of novelty. The industrial design under consider must be fundamentally different from industrial design that have been property or have filed for protections. The designs must also be so fundamentally different from similar industrial designs that have been published or publicly disclosed at home and abroad. That's based on that. The person with a average of qualification in the respective field can be industrial design, can be implemented. To evaluate the knowledge of an industrial design, say in an application, a combination of the set of basic design features of that industrial design with the set of basic design features of incidental industry designs must be made. The closest duplicate or similarity use a reference industrial design found during information search. Article 65 of 2005 Intellectual Law Amendment and Supplement in 2019 note the novelty of industrial design. Accordingly, an industrial design is considered to be novel if it is significantly different from industrial design that have been published disclosed in the form of use, written description, or any other form in country and or above before the filing date or priority date if the industrial design application enjoy priority. 2 seconds. The inventiveness of industrial design in terms of the relativities of industrial design. An industrial design is considered to be relative if it is based on industrial design that have been publicly disclosed in the form of use, written description, or any order from in the country or above before the filing date of priority date of the industrial design registration application in the case that the application is entitled to a priority. Such industrial design cannot be made an easy way for people with average knowledge of the respective files. First, there are two ways for consider an industrial design, whether an industrial design is relative or not. First, that design is different from industrial design that are publicly disclosed using another object for comparisons. Second, the design will be compared with the level of knowledge of average person in the respective files. The relativities of industrial design request that industrial design have its own ethnic characteristics. It is the relativities of an order of the industrial design that make the industrial design a unique heuristic design solution compared to other industrial designs, making that industrial design different from other designs. And finally, the industrial applicability. In terms of industrial applicability, industrial design is considered to have industrial applicability if it can be used model format production operation with the appearance of that industrial design by the same matter. industrial or handicraft. An industrial design grade must also contribute to an economic purpose. That is, it must be made products to be able to sell the products to the maker to raise a certain economic value. Go to the question 4. Determine the infringements. The bottle design of canvas has directly infringed the intellectual property rights of Unilever. Thus, the sunlight dishwashing liquid product has been granted a trademark registration certificate under trademark registration no 16,616 date to 2011 and were grade an industrial design painted no 13,708 by Unilever and the companies on October 15, 2009. On March 27, 2014, Unilever and the company signed a technology transfer contract with Unilever to transfer the intellectual property rights of own brand and design to Unilever. First, according to Clause 1, Article 141 of the Intellectual Property Law, Unilever companies either license of the right to use sunlight bottle design. In addition, according to the property provision of Clause 1, Article 126 of Intellectual Property Law on Act of Infringement of Urban Right to Inventions, Industrial Design and Layout, Article 5 and 10 of the Regs No. 105, 2006, that September 22, 2006, detailing and building the implementations of a number of articles of the Intellectual Property Law on protect of intellectual property rights and statements of intellectual property, the production and sale of canvas, dishwashing liquids with intrusive bottle designs by a Davidson company without permission of the owner is an infringement of the right to the protected industrial design bottle and the provision of the law on protection of intellectual property rights. Move to the question 5. Sanction for handling infringements. At the first instance court hearings, the plaintiff only asked the court to consider a part of the content request in the petition, namely to recognize the content agreed by the party at the court. The plaintiff and the defendant have agreed to request the court to cancel the provision emergency measures that has been applied under decision on application of provisional early measure no 30 to 2015 they choose 1 2015 of equal parts opportunities. Davidson company didn't question or comment about these measures and together with a plaintiff request the court to return the guaranteed money to Unilever. Person to Article 220 of Civil Provision Code consider that the consider of the agreement of the involved parties at the first instance court hearings in voluntary and not contrary to law and social ethnic to court recognize that the array of parties. The acceptance of plaintiff request as agreed at the first instance court of the court is responsible in accordance with law specified in Clause 2 Article 100 and 1A Clause 1 Article 122 of the Civil Procedure Code, and the court also accept the request of the party to agree to cancel the provision urgent measures specified in Clause 6, 12, Article 100, Article 108 and 115 of Civil Procedure Code, and cancellations of security measure under the decision on force in implementation of security measure No. 27, 2015 of People Cross Opportunities for Unilever Citibank. And final question 6, compare with European and US law. Group Japanese law introduced a concept similar to Vietnam's law on industrial design, which is the external appearance of products is expressed in shape, light, and colors. Japanese law also sets for requirement on condition for the protection of industrial designs as well as procedures in the registration of industrial designs. The term of protection of industrial design is 20 years. This term of protection is somewhat longer than the term of protection of industrial design under Vietnam law. With the Canada industrial design regime provides a flexible meaning protect the ethnic feature of an article. Its shape, configurations, pattern, or ornament. Any combination of this feature. Color is combination with other feature may not be protected. To be registrable, an industrial design must be novel over design public, disclosed before the period date of the application, and design disclosed in application with an early priority date. Public disclosures by the application up to 12 months before the priority date are not considered prior art. Additionally, early application filed in Canada by application within 12 months of the application are not considered period art. In addition, under the U.S. intellectual property law, industrial design can be protected by copyright and patents. In addition, the external characters of products are also protected by trademarks. There are factions related to the external appearance, such as packaging of the product that is not function, but represent the origin of the product. The appearance of the product is subject to a registration for industrial protect and is not required to be restricted for copyright and trademark protection under U.S. law. So I finished the comment exercise tools, and next Baduk will present the exercise tools.
Okay, so we move to the Pizza, Trader Joe, and the Coe Highland. The defendant, Michael Normal Highland, purchased the Trader Joe's brand, Trader Joe's Trademark, used in Washington State, transported to Canada and resold them there in a store he designed to a mini Trader Joe store. Trader Joe under the Lanham Mark and the Washington law, the state. The panel concluded that the Trader Joe applies a nexus between the Highland conduct and American commerce visit to warrant the external application the Lanham Act. So the legal issue whether or not the defendant conduct violates the Lanham Act. So next, the subject in the dispute, and the trader chose is the well-known American grocery store that sell the special good at a reasonable price from the James to the South Pacific, and about the 80% goods of the Trader Joe. In this store, Trader Joe trademark product that is available only at the Trader Joe maintains strict quality to control the standard while transporting and storing the goods to protect the safety and customer. That the he reject offer from third party to enter agreement in part because of the difficulty to answer that this third party will ship handle store, and the Canadian consumer related travel across the border at a short trade and are located in the northern Washington. So the Trader Joe classmen under the Washington law. The first is the federal trademark infringement, and to the unfair competition for endorsement and the designation of the origin, for link advertising, federal trademark dilution, state trademark dilution. Six is deceptive business practice in violation of the Washington Consumer Protection Act. The three is what are the conditions of protection. So the merits of the Lanham Act is the Alice violation creates some effect on the American foreign commerce, and the second, the effect is the sufficient to present a cognizable injury to the plaintiff under the Lanham Act, and the third is the interest and link to the American foreign commerce and sufficiently strong in the relation of the other nation to justify an existence of extraterritorial jurisdiction. So the quality control, the theory of the infringement, that is the cognizable under the Lanham Act, who are notwithstanding the first shell doctrine distribution of a product, thus does not meet the trademark holder quality control standard, which is so in the evaluation of the mark by tarnishing its image. So we determine the infringement, and the Trader Joe Island his commercial activity in the United States as part of the infringement scheme. According to the Trader Highland sources, his inventory entitlement from the United States, he purchased the housing. Higher operation may assist in the party in the U.S. Applying the Lanham Act to the foreign conduct of permanent residence to alien to who reside to the run business of the United States. And the compliance also the Highland began hiring third party in Washington and reasonably United States citizens to purchase shareholder goods on the behalf when Trader Joe refers to the serve him as a customer. And the timeline of wrong tree. The first is a degree of the conflict with the foreign laws. Second is nationality of the party and location of business. Third is remedy and enforcement. Fourth, relative significance of the effect. Fifth, the purpose to harm American commerce and foreseeability. And finally, a relative enforcement of the conduct with the United States compared to the conduct abroad. So we move to the sanction for the infringement, the trademark dilution. So the Lanham Act on the TDRA of 2006 provided the owner of the well-known mark that is distinctive whether by itself of those you has right to grant a rejection order against order at any time. And at what point after the trademark owner become well known, begin to use a trademark or trade name that is likely to obscure to in a way that is delusion by blurring and shadow or overshadow in manner that the Chinese at a well-known mark, regardless of the whether or not that is the possibility of confusion or the fact of confusion, competitor or the economic harm. So the Berlin is understood as the gradual reduction of the distinctiveness and impression in the trademark of private name by use signal identical or similar to the trademark of private name for a group of competing goods. And the chastisement occur when a well-known mark is used by the another party in an appropriate way to the render, and then in its devalues or the empire. Usually, this is using the same or similarly sign involving to consent. That is the unicorn, such as violence or the cocaine. Such as the theme that is contrary to the opinion of the trademark owner, or the issues that directly condemn and to attack the owner of a trademark or produce the serve and unauthorized the use of trademark is concept of the ethical violation, marking a bad association with the illegal drug adversary, affecting the commercial advantage and the reputation of the owner. So in the Consumer Protect Act, so the state claimed under the CPA advantage must actually is unfair or deceptive act on the practice. And number two, is occurring in the trade or commerce. First is a public interest impact for plaintiff in his or her business or property and file in the causation. So now we will compare with the European and US law. In the US, we have the term the trademark, and maybe at the overall interest, maybe include the word, name, symbol, device, or the combination of the above use or intend use in definition to distinguish the good of my manufacturer that in order to indicate origin to the good sign that have a meaning, a symbol or device, maybe a talk and the letter, number, graphic entries, 2D or 3D sound, scent, color, and a combination about the factor. In the European, we have the community trademark system in the right to know 4094 and the regulation no 2015. It is a separate system of the each member that's the valid within the territorial each of the method sequence of the registration and protection request the trademark. So we can search the trademark protection and condition. In the first, is the most the discriminatory, and second is not the functional, and third is not likely to cause a confusion with the other sides. And the trademark and subject matter to intellectual property rights. So we can search in the material. So I can give you some of the relation of the trademark and the trademark. Trademark and trademark is compared with the object with the intellectual property rights by their two objects considered in the Lanham Act, the United States Federal for the protect the trademark The primary purpose of the act to protect both consumer and the compliance from the miniformation from the product and service. In some countries around the world, the trade dress is often protected by the equivalent and the trademark. So the trade dress and the patent. Trade dress and the patent is a technical solution as known as the patent invention, which has a inventiveness and industrial applicable. The purpose of the patent rule, the patent protection in the invent by allowing the inventor to fulfill the second purpose is necessary to the invent will be free to use when it is expired. While the basic purpose of the protect avoid the consumer confusion, protect the seller reputation and advantage and enhance the competition. And trade dress and design. Trade dress and design. In a design must follow novelty, original, clear design in terms of shape, product, and industrial design. Protect the period despite it can be rechanged at the trade dress or protect under both. If the trade dress is used to indicate origin of goods and service, the design are often the ethnic and in order to attract the customer. So we the unfair competition in relation to the trademark. So the basic in the convention in the Paris Convention and PCT and TRIP. So it first is the behavior of that cause confusion. Secondly, the act of is creating the competition, and third, the conduct may be defined the public and the legal basis in the Article 10. So Article 10 here they are the indication or claim the use within the commercial activity likely to be misleading to public and the nature, the manufacture, natural, suitable for use or quantity of goods. So you can search in my material to open to see the law in the controlling the unfair to the competition to the related to the trademark in Vietnam today. So thanks for listening.
Ok, rồi bây giờ các bạn sẽ chép cái câu hỏi vào bên cái group Zalo nha.
Dạ vâng thầy. Dạ.
Em nói bạn Thúy Vi với bạn Vi đánh câu hỏi bên group Zalo á. Rồi sau đó xong buổi hôm sau chúng ta sẽ trả lời tiếp nha, những câu hỏi này. Và nếu nhóm trả lời được câu hỏi nào thì các em trả lời trước ở bên group Zalo. Rồi buổi họp hôm sau thì thầy sẽ trả lời trực tiếp, tùy nhóm em chọn thôi. Nhóm em có thể là hôm sau trả lời cũng được, trả lời trực tiếp với bên group Zalo cũng được nha.
Yeah, ok.
Ok chưa?
Yeah.
Rồi ok. Như vậy thì chúng ta sẽ kết thúc ở đây nhé. Và hôm sau 3:30 nha. 3:30 chúng ta sẽ vào để chúng ta làm cái môn thứ hai. 3:30 là vào để làm môn thứ hai. Alo.
Thầy ơi.
Hả?
2:30 hay là 3:30 vậy thầy?
Thầy đang có cái cuộc họp ở trên trường á. Không biết khi nào xong, nếu mà nhanh thì có thể là 3 giờ. Còn nếu mà chắc thì 3:30. Mình sẽ nhắn lên group nha. Mình sẽ nhắn lên group nha.
Dạ vâng, dạ vâng.
Rồi, tầm 3 giờ tới 3:30. Ok, như vậy cảm ơn tất cả các em. Cái buổi presentation today, and it's very very good presentation. Your group already present and prepare the writing. It's very colorful, very informative. So in the next section, I will give more comment on the writing and then answer more questions from discussion group. So first of all, your group just answer any question in the yellow chat box, and then we reserve another question for the next section. Ok, rồi như vậy hẹn gặp lại em vào lúc khoảng 3 giờ 3:30 nha. Mình sẽ nhắn lên group nha.
Chào thầy.
Rồi, bye bye Vi nha.
Right.
Em chào thầy.
Bye bye đấy.
Rồi.
Yeah.